5 or 6 seconds, I have noticed when we look at the video. Okay, I think we're there. Hi, I'm Ray Dickey from South Carolina CAI. Thank you so much for joining us today. We are guests of Ravenel. Cameron, thank you so much for having us.
Thanks for being here.
We are going to talk about the Fair Housing Act and civil rights. You don't want to mess up on the Fair Housing Act. Big problem, big trouble, lots of money. You just don't want to do it. Before we go any further, let me launch a poll for those of you that are here for CEUs. If you require CEUs, please click yes. Everyone has a question feature. I love getting questions and comments, and so does Cameron. We both absolutely love it. I feel lonely if no one sends me questions and comments. Feel free to ask whatever you like. I don't use people's names. However, don't ask me anything too top secret because you never know when I could make a mistake, but I've not made a mistake yet. But please send questions and comments. We want you guys to learn what you want to learn about. And quite frankly, sometimes it helps a lot with the way we do the programming. Okay, so I'm going to end the poll. If I ended the poll before you had time to fill it out, don't worry. Use the question feature and say, hey, Ray, I need CEUs. So send us questions, send us comments. With that being said, let's introduce our panel, starting with our host, and that would be Cameron.
Hi, everybody. I'm Cameron Lay with Ravenel Associates. I am our Director of Training and Development and Senior Manager. Thanks, everybody, for being here.
And I want to thank you, Cameron, for inviting me last week. I got to meet different offices, different properties. Cameron was running around like a maniac that entire day. I noticed. I don't know if that's your everyday scenario, but you were certainly running around a lot that day, and it was great.
I had a board meeting.
Yeah, yeah, you did. You're right. You had a board meeting right in the middle of everything, but I loved it. I absolutely loved it. And I think I was telling Kristen, you remember what I was talking about, Kristen? What do I like about meeting the managers? If you don't remember, how a lot of them, how much they, go ahead.
No, go ahead.
How much they love their jobs. Because most of the time I only interact with you guys on the live streams, but I love, managers love their jobs and they love their communities. Okay, enough said. Kristen, why don't you introduce yourself?
Hi, everyone. I am Kristen Serini, the Area Sales Executive for McGriff, a Marsh & McLennan company, and we specialize in community associations.
Awesome. And Valerie.
Hey guys, I'm Valerie Garcia Giovanoli, and I'm an attorney at McCabe Charter in Beverly. We're a full service law firm servicing community associations. Our headquarters are in Columbia, and we also have an office in Mount Pleasant and Charleston.
Okay, so before we go any further, there was some like breaking news, like first thing this morning. I don't think anyone's had a time to check it out, but Valerie, I want to just kind of throw it over to you. So maybe you could summarize what the breaking news is.
Yeah, so HUD, which is the Housing and Urban Development Agency, it's a federal agency, just released actually 2 publications, essentially saying we're reversing course on our prior policies and the enforcement of discrimination violations under the Fair Housing Act. And I haven't had a chance to read those 2 publications. This is legitimately breaking news. I have reading material for afterwards, so I'm not prepared to discuss the specifics. However, I will say that it was generally my understanding is that the policies are changing to focus on intentional systemic discrimination rather than the disparate impact, which is more of a neutral rule that may impact people disparately. They also are prioritizing where they're putting their resources on what types of cases, focused on more of a case-by-case sort of analysis rather than just kind of the guidance that they previously gave us. So I think it's going to be good. I haven't had the opportunity to read those documents. I would encourage everybody to look at them themselves, and maybe we'll do another live stream where we can discuss those specifics.
Absolutely. And you referred to, what was the desperate, you mentioned
Disparate.
something.
Disparate.
Can you tell me what the difference is? There was something before that, and then there was that. What is the difference?
Disparate impact is like unequal impact. So where you have something on its face is neutral, a rule that might be neutral, but it impacts a certain category, a protected class unequally. So for a good example that I could use would be background checks or having some prohibition on people, certain convicts. It has been said that that impacts maybe racial minorities more than it would impact other people. And so that type of thing where you might have something neutral that applies to everybody, but it has a disparate impact on a certain protected class.
Thank you. Kristen and Cameron probably knew it already, but they know a lot more than I do, but I had to ask, so. Awesome. If it's okay with everybody, I'd like to just do a couple poll questions just to see where we're at with the program, and then we can fall back to them if we need to. And the first one I want to start off with, and we're not going to give the answers right now, unless Valerie wants to do it that way. I'm perfectly happy to do it anyway. Valerie wants to do it, but let me launch the first poll. And I say this all the time, I really don't like my poll system. And the question is, violations are only considered civil, so not criminal. Did I say that right, Valerie?
You said that correctly.
Okay. And I'm going to let that pull up here. And I think you guys can see the results as they come in, right?
Yeah.
Valerie, do you want to talk about the polls as we go through them? Maybe that would be easier instead of backtracking. What do you think?
Yeah, I think while people's brains are there, that it would be helpful for them. Do you want me to log into it before that you close the poll, or let her?
No, I'm going to close it right now. So 63% said true and 38% said false. So pretty split.
63% are correct. They are only civil, and we're talking about violations of the Fair Housing Act, specifically in the community association context. That's not to say there cannot, the conduct leading to a violation of the Fair Housing Act can also be criminal. For example, if you commit a hate crime or you threaten someone's life because they're in a protected class, that could also be criminal. But what we're talking about with violations of the Fair Housing Act are civil. There is no criminal prosecution as part of that process.
I wonder why I came up with that, but I'm also curious. People were definitely split on it. Do you know what I'm saying?
Yeah.
So that was interesting. Sexual orientation is a protected class. And let me launch this one and we'll see where everyone comes through here. Cameron, this can kind of be confusing stuff sometimes, right?
Yeah, definitely.
Because I think this would kind of fall into like a manager or board member's best intentions, right? And they can kind of maybe fall into this trap. I don't know if you agree with me or not.
Yeah, this is a tricky one.
So I'm going to go ahead, and I know Kristen has a lot to say about this from the insurance end. It's really complicated. So 82% said true, Valerie, 82% overwhelmingly. So is sexual orientation a protected class?
I think that it was a trick question, and I did not talk to Ray before this, but I think it's a trick question because technically, no, it's not a protected class. However, HUD's guidance, they have included as a category under the protected class of sex to protect sexual orientation and actually gender identity as well. And that was not until 2021. The actual statute protects sex, which is female, male, men and women, discrimination based on sex. But it wasn't until 2021 where HUD said, hey, we're going to consider sexual orientation and gender under this class of sex. So it's not its own class, but it is being considered under the protected class of sex.
So you can get in trouble for discriminating against someone based on their sexual orientation.
Potentially, yes.
Potentially. Okay. I love gray areas, Valerie. I absolutely, I love them. I love that.
Well, I say potentially because Ray, remember the guidance that was just released, they actually withdrew prior guidelines set by HUD. So right now it might not be considered and included in that class, but as of prior to that publication, it has been since 2021.
The next one is under 16, not allowed in the pool alone. Is this acceptable to have a rule or a sign that says, hey, if you're under 16, you can't be in the pool alone? And I see that a lot at associations all over the place and all different kinds of states. I think Kristen probably knows the answer on this one because it can also get involved with insurance. And this is a much debated one. So 50, 50, 44, 56. I'm going to end the poll. And you can always send me comments, by the way, if you have some additional comments, audience. All right. So that one is basically split, Valerie. I am not surprised.
Actually, I think it's another trick question. Because there's a kind of a variety of case law out there. And in fact, South Carolina has none, but we're talking federal law. Each state usually has its own version of a Fair Housing Act. But nonetheless, in Tennessee, there was a case where a 17 and under had to be supervised by parents. That was rendered discriminatory. But there's a California case that said 14 and below was not discriminatory. And the real decisions hinge on whether or not there's a legitimate reason for the rule. And everyone ties it back to, well, it's dangerous for a child to be unsupervised. But if a child knows how to swim, lifeguard, but to become a certified lifeguard, most states it's 15 years old. You can't really say that's a legitimate reason if a 16-year-old is fully capable of swimming, sometimes better than older people. So you do have to tie it to a legitimate reason, and safety would be a legitimate reason. And so what I'm finding, or what my guidance would be, is more towards the 14 and younger, with maybe a carve out if a 14 or 13-year-old can demonstrate swimming proficiency. So then it's tied back to whether or not that person can swim. It's not just, hey, we don't like kids at the pool, they act crazy when their parents aren't around. That has not been found to be a legitimate reason, purpose.
It makes a lot of sense because I can almost guarantee every 16-year-old in reasonable shape is a better swimmer than I am at this point. So it would definitely, let's face it. I mean, who do you want diving in for you, audience? Me or the 16-year-old? Come on, let's be honest. All right, one last one.
Licensed lifeguard.
Right.
One more, that's it. And I like how this kind of sets the tone for today, that it's not so easy with what is going on. And I don't try to make them trick questions. They're just confusing. It's a confusing industry. It's a confusing topic. This one is, are all civil rights and associations must be followed. All civil rights. That's my civil rights. How many times have we heard that? You can't keep me out of the pool. That's my civil rights. Everybody, right? Cameron, have you ever heard in your career anyone tell you that you're violating their civil rights?
Yeah.
Would you say you've heard it more than 10 times?
Maybe not.
Okay.
Maybe not more than 10.
All right. So this one came in, Valerie, 64% said false. It's pretty much split though at the end of the day, anything that close. So this is another tough one. Where are we with this one?
Well, I think everyone's right and wrong. It depends on what civil right you're referring to. And so when you say civil rights, I mean, there's a litany of them. But for example, the right to free speech is one that you often hear about being a civil right, and that is not necessarily protected in an HOA. That most of those apply to government entities, and an HOA does not constitute a government entity. Maybe there's some arguments that they're quasi-governmental or certain actions they do. Likewise, with right to bear arms. I mean, you go to the clubhouse and there's a rule that you can't have a gun, then that's enforceable. And so I guess I don't consider that a violation of your civil rights. Rather, it's a private entity, and if you want to go into the clubhouse, you have to, forego some of those civil rights. But I will say that due process is a civil right that I do think is applicable in the community association context. You don't hear about it too much, but you go to court on a covenant enforcement case and you're trying to collect $5,000 of fines. Person never got notice of the violation, never got an opportunity to be heard. Court's probably going to say, hey, I'm not enforcing these fines. I'm not going to make them pay them. You guys should have exercised due process, afforded them due process, provided them notice, an opportunity to cure the violation, et cetera. So things like that could be applicable in the community association context.
So theoretically, private would be like your own home to one extreme, or also the association clubhouse, right? If you don't, as long as you're not letting the public come in, and you're probably going to talk about that in a moment, but a mall, give me an example. We all know what a public place is. A public place would be a park. A public place would be, I don't know if City Hall would be a public place. Can you tell me what that would be?
So I think we're conflating public places with government properties, government controlled properties. So let's say a shopping center that's privately owned but open to the public, they're not subject to a First Amendment. You have to let people bring guns into this. That's why movie theaters and other places are able to sort of restrict that. But government property, so you think, that type of thing, you go protest on the courthouse steps, I can't even talk, and you can't silence free speech there. So those are types of civil rights where the government cannot silence those. unless there's like a very legitimate purpose, like not taking guns into a courthouse. But nonetheless, I would say that like a mall it most likely is considered still private property. It's just open to the public as an accommodation open to the public for retail services. Community association is mostly, even if they open their property to the public, let's say they have a swimming pool where they allow a swim club to come in from people that don't live in the community, they can still govern their community. There's still people that show up aren't entitled to say, hey, I have a civil right to, protest politically here. It's still private property, and we still have the right to govern and regulate the conduct and what happens on that private property.
And a lot of this stuff has ended up in I'm going to drop it, but the Supreme Court. These are complex issues.
Yeah, for sure.
Okay, so let's get rolling. Cameron or Krista, do you have any questions about the polls or any commentary?
Oh,
Okay.
good poll.
Okay, excellent. So I'm starting off with problems and pitfalls, Valerie, but I think you should explain maybe what the FHA actually is. And is it appropriate that I put it with civil rights? I did it for like a marketing reasoning, but can you jump on that for me a little bit?
Yeah, well, the FHA stands for the Fair Housing Act, and that's a federal statute that essentially prohibits discrimination on the basis of 7 protected classes. And I think we'll get to that later, but it applies to community associations, and that's something that a lot of HOAs actually don't know. I know we're talking about problems and pitfalls, but it gets confused with ADA. ADA is a law that applies to public accommodations, kind of in the same vein of what we were just talking about, a shopping center, a hotel. But it's actually the FHA, which has parts, the same similar provisions of the ADA, and it applies to HOAs. And a lot of boards and managers sometimes don't know that, especially new managers or board members. So I think that right there is a pitfall, that they don't know that they are subject to the Fair Housing Act. I'd say another big pitfall that I'm seeing since 2016, and again, this may be different based on the new publications, but in 2016, the HUD adopted a final rule that essentially created vicarious liability on HOAs for discriminatory conduct by third parties, not the HOA, not the board, not their agents, managers. Prior to that, if you had a neighbor to neighbor just fighting, and maybe they were being ugly and using racial slurs against each other, you would just stay out of it and say, look, y'all are obviously, you guys need some etiquette schooling. But we would stay out of it. And now, if the HOA knows or should know about any discriminatory conduct that's creating a hostile environment, they actually have to take whatever actions and tools are available to them to quell that. And so we can get into that, but I do think that a lot of people say, look, the board didn't do anything. That was, Joe Smith over there. They don't get a get out of jail for free card now. There's now vicarious liability for that actor's conduct on the HOA.
So to me, I think this may be one of the biggest items in our session today. So basically you have 2 neighbors. One is a protected class and the other neighbor has a dispute and they're using racial slurs, or maybe they're putting up signage that could be considered a hate crime. And the HOA board says, you know what, we don't need to get involved with this. Just deal with it on your own or call the police. But what you're saying, Valerie, is the HOA 100% could be dragged into this and then suffer penalties and liabilities. This is a pretty big item, correct?
I agree, because it really, it's a very difficult territory to traverse, because the board's like, well, what do we do? I mean, how much involved do we get? On the one hand, we have courts saying, hey, HOAs, y'all are way too hands-on, stay out of people's business, you don't get to run people's lives. But on the other hand, it's like, no, you do have to go and be someone's mama and teach them how to be a civil citizen. So it's really difficult, but I would say that the best path forward on that is if you know about some type of discriminatory conduct, at a minimum, sending a letter to say the HOA doesn't tolerate this, please stop. The HOA is also going to be limited by the resources available to it. They're governing documents. If we don't have fining authority, we don't have a right to suspend privileges, we don't even have any provisions that we can use to enforce. This law doesn't give us more tools or more enforcement remedies. We can only use what we have available to us. And so, like I said, even a letter letting them know that the discriminatory conduct will not be tolerated. If you have the ability to fine, you can then put them on notice that they will be fined for any future violations. But that is protecting the HOA because you were taking steps to eliminate the discriminatory conduct. And that's essentially what the HUD is aimed at, getting more people to help stop the discrimination.
You know what I don't like? You know what I don't like about this, Cameron? And then we'll jump back over to Valerie. And we're not going to forget about you, Kristen, either. Don't worry. Here we are, like the more obvious cases I'm not worried about, right? But these gray areas, here we are once again, where managers and boards, maybe it's not discriminatory, maybe it is. There's a big gray area here sometimes. Do you agree,
Yeah.
Cameron, before I go back to Valerie?
It can be tough, and I think that's where boards and managers need to lean on their experts, like Christian and Valerie, legal and insurance, to make sure that they're doing the right thing.
Before I go to Valerie, Kristen, about this gray area, where are we with the insurance?
You want to make sure that you're properly insured, right? You want to make sure as an association that you have adequate directors and officers, otherwise known as D&O insurance, and you need to make sure that you have adequate general liability insurance. And then I would encourage associations to make sure that they also have an excess liability or umbrella policy, just because we have seen a lot of nuclear verdicts that are coming from things lately that are going through the limits of liability on either the D&O or the general liability policy when we're getting into lawsuits. And so it's the payouts are having to come from those excess liability policies. So that's the first step, is working with your agent to make sure that you have adequate coverage in place
That sounds terrible.
prior to something happening.
A nuclear, what did you call it? A
Or
nuclear payout? That sounds absolutely horrible. I don't want to be involved in that. You know, Valerie, it's not uncommon, justly so, sometimes that people who are a protected class can perceive something as discriminatory, and it really wasn't. And it's hard for board members because they know the people, they live in their communities, and maybe they know that Joe's not actually discriminating. What should managers do and boards for the gray area, right? Like, where's the line here? You know, how much should they investigate? How many questions? It's like a trap here. How many questions should the manager start questioning all the parties to determine if this is a discriminatory act?
Right. All really good questions that I myself ask. And it's difficult. Again, that's why it's a problem and a pitfall, is that where do we draw the line? When are we encroaching into people's private lives? What does an investigation look like? How do we just, because if someone makes an allegation, I've been discriminated against, do we just say, you're right, and we have to take action against this person? Do we have to go interview people? Do we need to review video footage? Those are all questions that the association is asking. Our boards are asking, and my general guidance, because these are very much case by case, is to at least take some effort to figure out, do some type of investigation. And typically you want to have some policy. Talk to the complainant, talk to the person that they're complaining about, the respondent, I guess you will, at a minimum, because you've got to hear both sides of the story. As far as fact finding and making a conclusion, I think boards are not equipped to do that. And so again, if I'm going to protect the association, I'm going to send a letter that doesn't accuse, hey, Joe, you absolutely discriminated, unless our investigation yields that, and it's obvious. But you just say, hey, we've been made aware of this. We want to reinforce that we don't tolerate this. If there is any other additional contact in the future that violates the FHA, is discriminatory in any way, then we will take this action. And that's sort of, I think, the best strategy. There's obviously going to be circumstances where it is flagrant discrimination, and we have got to address it. We have to maybe take more serious steps, but there's not really a one-size-fits-all approach to it. It is certainly case-by-case basis, and I certainly don't envy the position that the boards are in when they have to determine, where do we even start? This is a volunteer position. Now we're doing investigatory processes. And I think a lot of managers are falling in that same bucket of that the boards are delegating it all to them. And they're like, hey, where do we start? So I do think at a minimum, talking to the complainant, hearing them out, what happened, if they have evidence, reviewing that, and then listening to the respondent as well, and documenting your file that you have done that. Because essentially, at the end of the day, if a complaint's filed against the HOA, we just want to demonstrate to HUD, to SHAC, whatever agency is investigating us, that we took the steps that you're requiring us per your guidelines.
let's break it down a little bit because this is so important, right? Cameron, this terrifies me, right? Because now the board is getting involved with an individual who already feels discriminated against. The board may ask the manager to get involved, and the manager or board may ask the wrong questions, and that itself could be taken as being discriminatory. So now the association is also involved as a party that aggrieved them. This is what I find so terrifying about this, Cameron. Do you agree, or it's just a tough one?
It is. It's really sticky. It's very uncomfortable as well.
Valerie, for me, this has like lawyer written all over it. Lawyer, lawyer, lawyer.
Yeah, so I would suggest, and obviously if you get a complaint, my first recommendation would be to seek legal counsel and your lawyer can handle this stuff. However, I do acknowledge that that is expensive. Most lawyers charge hourly and in order to go and investigate and ask questions. So maybe a better approach is to go ahead and have a standard set of questions that can't be deemed discriminatory. And what I mean by that is you're not quizzing them and then pushing back and saying you don't believe them. You're just gathering information. What happened? What was the date? Specifics as to a detailed description of what actually occurred. And then the same for the respondent as well. And I don't, again, I do, this is one of those areas where it's very difficult because a lot of boards and managers want to handle this stuff procedurally on their own without having to engage counsel. A lot of these associations do not have huge legal budgets. I acknowledge that. So this general guidance is exactly that. But if you want to prepare a list of questions, have your lawyer review those, and that could be the questions that you submit to any complainants, then that's probably a good way to address it. However, I do want to say again, because this is such a gray area, I would strongly recommend that the board or management consult with the association's attorney when they get these types of complaints.
I love the idea where there's a list of questions, Valerie, for a couple reasons. And maybe the board or manager, you'll tell me if I'm right or not, should not deviate from that at any point. So maybe they work with an attorney and they say, this is like a police report. This is basically good. Anytime we get a complaint about a discriminatory action, maybe they have the people fill it out themselves and maybe the board doesn't even ask them. The other reason why I like it, Valerie, too, and tell me if I'm wrong, is because I'm afraid the boards and managers are going to also vary. They're going to get involved in one discriminatory case, and then it's human nature. They're going to ask a completely different set of questions in another one. And that part makes me nervous also. Innocently.
Yeah, that's like with anything, the beauty of having policies and procedures in writing that no one deviates from, because you do have different personalities on the board and management. And so that is definitely a potential solution. You can't say that a director is not going to deviate from it, but if the association has those written policies and procedures, we're better protected to the extent there's an investigation and we can provide that stuff. If a manager or a director went off script, there could potentially be personal liability to them. But so long as we have policies and procedures and we are implementing those and making sure the directors and managers are following those, we should be pretty well protected from a civil penalty.
And audience, did you hear Valerie? Personal liability.
Yeah.
Well, that's the most terrifying thing of all. If you're a board member,
Yeah,
right?
Absolutely.
Kristen, any quick commentary on personal liabilities?
It's just that it comes down to, as Valerie mentioned, I said earlier, making sure that you have adequate D&O for directors and officers in place. So hopefully you don't have to bear any personal liability, but there are clauses in those D&O policies that are going to put you back to like your governing documents. And if there's any sort of malice, if there's any sort of negligence in play, then yes, there could be a loophole and there could be personal liability coming into play if the D&O is not going to cover you because you essentially went off script and you didn't follow what your professional advice.
Cameron, do I now have permission to scare the audience? This is the part I have to do as part of my job to make them like, I feel bad, but to make them pay attention and take this seriously. Do I have your permission to start that process?
How
Okay.
we did let's do it.
All right. Now, audience. All right, Valerie, you don't want to screw this up. Can you explain why?
All right, so let's talk about the penalties. Maybe talk about the process next. But Penalties can be pretty high, and they're mostly monetary. So the different types of penalties could be the actual damages of the victim of the discrimination, if you will. If there were any damages, maybe reputational harm, loss of business, emotional distress, all of that type of stuff could be awarded, and that actually goes to the victim of the discrimination. They also could do what we call an injunction, which is basically some order requiring you to stop doing something or requiring you to do something. I've even heard of injunction saying this person must be removed from the board because they were discriminating against somebody in the community. So an injunction is an order requiring something to stop or making the HOA do something, maybe adopt certain policies, that non-discriminatory policies. So there can be that. And then last but not least, the civil penalties, and those actually go to the state or the federal government, whatever entity is prosecuting, because you can be prosecuted by either. But those are, they're higher at the federal level, and I don't know the exact dollar amounts offhand. I know they go into like they're progressive. So the more you do it, the higher the fines get. In South Carolina, they're less than the federal government, but they're $10,000 up to $10,000 in civil penalties for your first act. And then it's 25 if you've done 2 within the last 5 years, if you've been found to have discriminated against someone in the last 5 years. And then if you've done 3 or more in 7 years, then it's $50,000. And those are caps. So your fines could fall below that. But there is a significant risk that you may have to pay some monetary damages or civil penalties.
Couple things that also scare me about this. First, we're talking, the intent doesn't have to be there to be found guilty of this. I don't know if the word guilty is appropriate. Valerie, is that true?
I mean, you could say guilty. We're not using it in a criminal context.
I mean, if you do it accidentally, you didn't mean it, it doesn't matter, correct?
Yeah, so that kind of goes back to that disparate impact analysis, where you've got on its face any type of rule, or you didn't intend it to have any negative impact on a protected class. Yes, you could still be found liable for violating the FHA. I will say that I think that the investigators use judgment, and I think the penalties in those circumstances are lower than where it is obvious intentional systemic discrimination.
The other part that scares me is you are fighting a governmental agency. You're not getting sued by another. They have an unlimited pocketbook. They don't care. This is what they do for a living. They go after these fines. You're battling the government. You're paying for your own attorney. So this is already like a loser situation. Am I right, Valerie, or wrong?
Absolutely. When we talk about litigation in any context, civil litigation, it's oftentimes about a battle of the wallets. And unfortunately, I have to say that phrase to a lot of boards where, they want justice. They have a great case, but it becomes a battle of the wallets, meaning who can pay more and, sometimes drag this out. That's an unfortunate reality. But in that same vein, you can't battle somebody who has the purse of the government. Unlimited funds, if you will, governmental attorneys on staff, investigators on staff. So that is a real significant risk the association faces. And we might have not have done anything, and I have to pay a private attorney to defend me. Unless, Kristen can chime in on this, there is insurance defense available. But again, I've seen that go both ways. The discrimination complaint comes, some policies cover it, some don't, some provide defense, some don't. And even with that, they may not pay any civil penalty. They may reserve their rights on that indemnification. And the last thing I would say on the insurance is that even if you do tender it to the insurance carrier, you may get a free lawyer, but it may have other impacts long term, like increased premiums, non-renewal notices. So it can still have a financial impact even though you get the free attorney. So I think Kristen might actually have
free attorney. I don't know if there's any such thing as a free attorney, and that's like the perfect point, Valerie, and segue is a lot of DNO policies, directors and officers policies, do have a clause in there to defend, but most of them have exclusions for penalties specifically involving civil rights and FHA. So even though you might have an attorney defend you, to Valerie's point, you're still going to be paying for those penalties or any incurred charges for that nature. And you are going to get that ding, so to speak, on your loss history, claims history for that DNO policy, which most will say, well, isn't that what insurance is for? Yes, it is there for the sudden and accidental. However, when you're going to renew your policy, carriers will ask regarding the claim, and anything that's going to be regarding FHA, civil rights, any sort of discrimination suit, they're going to ask at length regarding that claim. And to Valerie's point, a lot of times you might get dropped the next renewal by the carrier. A non-renewal will be issued, right? So you have to find coverage elsewhere. Well, the new carriers will want to know what's going on, and it's going to make the account, make the association harder to find coverage. And when we say harder to find coverage, that equals more dollar signs in the long run for the association.
Plus, you could exceed your coverage also if you don't have the right insurance, correct?
Yeah, and
Easily.
a lot of times most D&O policies have $1 million limit.
Sure.
That's where those excess policies I talked about earlier come in place. If you exhaust those underlying limits, it would pop to the umbrella or excess liability markets, which that's a whole nother conversation. But those markets are few and far between these days, and we're seeing very increased costs with those as well.
You know what is the impact, Cameron, that people don't realize, especially I think the attorneys and the insurance people, because they're used to all this. Now, Kristen and Valerie, they're like, what the heck is Ray talking about now? There's a good chance the insurance company is going to settle, and you're going to have this mark on your personal life. You've never discriminated against anyone your entire life, and there's going to be a settlement, and you're going to be found to have discriminated against someone in a certain manner. And to a lot of board members, that's very hurtful. You know, they went their whole life. Have you ever seen that happen, Cameron, before I go to Valerie on that?
I
You know,
have
the
not, fortunately.
but a lot of times the insurance companies settle and the board members are not happy about it, right? Because some guilt is transferred over to them. Valerie, am I wrong on that?
No, we could do a whole segment on this. I think, and this is no knock to the insurance defense bar, but you're right. A lot of times there are settlements where it may, if you look at that case in a capsule, that it is the best decision from a cost of litigation perspective, from a risk perspective. But the long-term impacts that has on the community is where we sort of lose that, because for that particular attorney, that might be their only time they ever have to deal with this HOA. I think the other attorneys that do community association law, and we serve as general counsel, and we live with those long-term impacts for our clients, it's pretty devastating. And I'm not only with the reputational mark or the PR issues, but also because you sort of set a precedent. And the next person who's a minority class who just files a claim, says, I'll get $7,500. They're going to make me an offer. And then again, you go back to those dings on that policy, and your premiums are going to go through the roof. And it sort of incentivizes frivolous claims. And I hope that we have an opportunity to talk a little bit about that and some maybe things I would like to see, and hopefully we're going to see with these new publications more objective standards. But yeah, I think it can have devastating impacts, and I think that not for any faults of their own, that insurance defense attorneys and adjusters lose sight of the long-term impacts to the client with the focus on, look, this is a risk mitigation, this is a best use, sort of a cost benefit analysis, and those all should be considerations. But because of my practice, I live with the outcome and the effects long-term, and they certainly are real.
Yeah, and that's all great, but all of a sudden the board member feels like they've been marked a racist. Let's face it. I'm just going to call it the way it is, because the insurance company, you know, had to settle, and the board member's like, I didn't do anything, and it probably many cases they did absolutely nothing to deserve it, and that's upsetting. And I just want to recognize that this is another reason not to make a mistake if you're a board member, because this is going to have an impact on you whether you think so or not. Okay.
And you know, Ray, I'm just going to add one more thing. We already have a problem with apathy with people wanting to serve. It's a volunteer unpaid position, and you're adding this onto it. It's unfortunate.
But this is something, Valerie, I feel like boards and managers can avoid if they follow these procedures, like you mentioned. Check with your attorney, have a pre-list of questions, walk very carefully. This is worth spending the money on to have the attorney review it. As a board member, why would you not spend the money? Why would you put yourself at risk like this? For who? Your neighbors?
You absolutely protect yourself there, but you're not going to prevent any type of frivolous type of complaint where you still have an investigator and you still have to hire an attorney to defend it. So I don't think there's any currently under the current, code and the rules. There's no way to absolutely protect yourself. There are certainly policies and procedures we can put in place so the worst case there is an investigation, you're not found liable, but you still have to go through that process. And it's the same with any civil lawsuit. Someone can sue you for something and you're
Right.
like, well, we didn't do anything wrong.
That's exactly what I meant, though. I'm
Yeah.
not concerned about the frivolous accusations. I could care less as long as it's handled properly and I spent the money and I got legal counsel.
Yeah.
I'm not going to worry about it as much, So, the role of civil rights. Did we already touch upon this enough, you think, or?
I think so.
Okay.
I think they're kind of a little bit related, but very distinct, and we could do a whole other segment on just civil rights.
Outside entities, you had spoken, that was another thing that scared me. Now, boards and associations and managers could be responsible for the actions of a third party.
Yeah, it's called vicarious liability, and there's obviously limits to that. So typically, if there is a third party contractor, let's say, we absolutely have no control over, they're not an employee, they're not a director, they're not an officer. We have no control over, their actions, their work. However, so I would say potentially no vicarious liability there for a 1099 independent contractor that comes in and does something. However, I do think that if you're put on notice that maybe the landscaper is yelling racial slurs to the minorities in the community, it would be in your best interest to cancel that contract and go with another vendor so that that isn't imputed to the association. But I think the first time you hear about it, you should probably take some sort of action. Whether or not there's vicarious liability there, I think is a case-by-case basis you would want to analyze. But likely not if it is a truly independent contractor.
Cameron, once again, though, this isn't something maybe a board or manager should just decide on their own. They need to spend the money and go to legal counsel. I don't understand why boards want to save money for their fellow owners who are just going to turn on them first chance they get. I'm sorry, boards. It's just the way the world works. You're just putting yourself.
It's going to be a lot less expensive to go to your attorney in the forefront than to have to defend a claim later.
So Valerie, I would say this is another one to maybe have some policies in place or some questions or whatever. Would you agree? You should.
Yeah, absolutely. And again, it's one of those, it's such a sensitive area because, again, you might have somebody who just doesn't like the landscaper alleging that they've, been discriminated. And then are you going to lose a good contract and a good contractor with an unsubstantiated accusation? So again, these are questions that I don't really have the answers to, but go back to those policies and procedures. You have questions, you submit the questions to the complainant to get the specifics of the situation. You can talk to your vendor. If you want to, say, hey, we don't believe there's any finding of discrimination and keep the landscaper or whatever your contractor is, then you run the risk of that complainant filing some type of discrimination suit. So that's where the investigation comes into play. Or if you want to try to alleviate any type of potential complaint from the potential victim of discrimination, then like I said, you could terminate the contract on that basis. You probably want your lawyer to review that contract as well. But again, if it's unsubstantiated, you may be losing out on a good contractor and a good contract with an unsupported claim.
Well, I think I would go to my list of questions and my procedures and follow them to a T and then send it over to the attorney and don't deviate in any manner whatsoever. Krista, do you want to dive in? Is third-party insurance have a role in this scenario?
It can, and to Valerie's, as the association, they're not an employee, but you are hiring them. So they're kind of a pseudo employee in the eyes of the insurance when it comes to like general liability under workers' comp policies. Now, when it comes to the litigation, it's basically going to be a lot of times if you don't act to what Valerie was talking about, the suits are going to come back onto the association. And that's where the gray area is going to come in. Obviously, the D&O policy is going to defend the association, the board, but the association policies are not going to defend the contractor in any way. And that's where, the contractor, if they're named in a suit, obviously that would go onto their insurance. There'd be there's a gray area there, and that's where you would want to bring in legal and kind of run it by them. But to your point, using a process and having that process and making sure you do that each and every time and not deviating from that, I would hope would help when you reach out to the attorney, and then they can kind of take it from there. But having that guidance, like I said, on the front side of it, be proactive and not reactive as an association.
I love this question. What about a homeowner yelling racial slurs at a landscaper? So let me make it broader, Valerie. A contractor could also sue the association in this regard if they're discriminated by, and it doesn't, it could be a resident too, right? It doesn't have to be an owner.
You know, that's a good question, Ray. Theoretically, I think they could. I don't know that anybody, any investigatory agency is going to take that seriously. And quite candidly, sitting here right now, I don't think I know the answer, yes or no, if there's an absolute, it has to be a member of the association or it could be some type of third party. I think there's situations in which a third party would be impacted. I know without a doubt it applies for our membership, but that would be something that I would take seriously and consult with counsel and figure out how to navigate that issue.
Another gray area. Okay.
Yeah.
Oh boy. I haven't forgotten that you want to talk about the frivolous cases. Don't worry, I have it right in front of me.
Ray, I'll just add that I want to add one thing to that because I mean I'm being honest. I don't know all of the particulars on that scenario, but the homeowners associations are subject to the FHA because they are considered housing providers, although we don't really provide housing like landlords in that context. So I would be inclined to say it doesn't apply the vicarious liability for a third party coming in because they're not providing any housing services rather. And so I would say no, but I don't want to rule it out completely. I haven't actually come across that fact pattern.
Do we have to talk about comfort and service animals? They don't belong in here, right? Right, Valerie?
No, I mean, they do. They're part of the Fair Housing Act. So if you want to talk about that.
Can we do it shortly? Because I feel like we talk about dogs all the time.
Yeah. Well, it's a big thing. So this is a little outside of discrimination on the basis of a protected class. Well, actually, it's actually specific to disabled, the disability class. So mental or physical disabilities is where the dogs and the animals come into play. And there's two types of protected animals. Service animal, which can only be a dog trained to assist the disabled person with something. CNI dog is the best example. Sorry, I don't know why my words aren't coming out today. And then emotional support animals, and that can be any animal. The HUD has given us guidance that exotic animals probably don't qualify, but they take it on a case-by-case basis. So we get a question a lot of, can my tenant or this person have a boa constrictor in my unit? The answer might be no on that, but dogs, birds, cats, I've seen chickens, those types of animals could be considered emotional support animals. And so both are a protected class, and both of those disabled people are entitled to reasonable accommodations for those animals. And I think maybe that is enough for this segment. Just generally, again, I think we should have written policies. If you have a rule that says no pets in this particular area, remember that emotional support animals and service animals are not considered pets. And so those people may be entitled to a reasonable accommodation. A good example would be in condominiums. We have breed restrictions or even weight restrictions on certain animals. And if somebody says, well, this is my emotional support animal, most times you're going to grant that accommodation and allow them to keep the animal. The animals still have to comply with all of the other rules and regulations. So, leash, noise issues. If the dog's barking all night, they obviously can't do that. As well as, picking up after them in the common areas, that kind of thing. They still do have to comply with those rules and regulations as any animal owner would.
Cameron, I love dogs, but oh my gosh, if I have to talk about dogs, I feel like I have to talk about dogs 4 times a week. Do you ever feel that like as a manager? I'm just sick of talking. I love dogs, and I'm sick of talking about people's dogs and people who don't. I'm just tired of it. I'll do it. It's my job. Are you tired of it?
Yeah, there are definitely times when I'm over it.
Yeah.
It's not going away,
Okay.
though.
Krista, do you have any commentary that you have to offer on dogs?
No, I had an emotional support monkey a couple weeks ago, though, so it's not just dogs.
Yeah.
I had one a miniature horse.
So it's not just dogs, Ray. It's not just dogs.
Maybe a monkey could be a service animal, but if it does a task. Oh my gosh, now I'm even doing it. All right, I'm going to the next slide. All right, did we even mention what the protected classes were? Did I ask you, or did you?
It did not.
No, you haven't. And I thought that we were going to get to this. So
It should have been
there
slide
are
number
7.
1.
What's that?
It should have been slide number 1. What was I
Yeah.
thinking?
Well, there's 7 of them currently, and like we mentioned in the prior slide, sexual orientation is not a class, but it falls under the sex class, protected class. Race, color, national origin, religion, sex, disability, and familial status are the 7 protected classes.
People with disabilities. This one's a pretty obvious one, right?
Yeah, that falls into
Okay.
the disability class.
All right. This is the last one I have, then we'll just kind of go to the frivolous. But I want to mention this one, age, because I think this is an easy one to screw up on. Do you agree, Valerie?
Yeah, so that goes to the familial status. And a lot of people will be like, oh, well, that's age discrimination. And there's no such thing as really age discrimination. It's the impact on families. So when we were talking about the kids not being able to go to the pool without supervision, that affects families in a different way than it would affect single persons. Likewise, another area we find age come into play where it touches on familial status is 55 and older communities. And people say, well, isn't that age discrimination? Well, it could be familial discrimination, but the government has decided that there's an exemption, and you have to comply with all of their rules and regulations in order to have a 55 and over community. But those are kind of the areas where you're seeing age come into play and then tie back to the protected class of familial status.
Yeah, I want to be an astronaut, and I can't be an astronaut. I feel like that's age discrimination, Valerie.
Well, your age is not a protected class. Sorry.
Oh boy, no one can help me. Okay, let's talk about, well, let's talk about frivolous. You wanted to bring up frivolous lawsuits.
Well, I just wanted to kind of make a general comment that, you know, there's no solution to the problem I'm about to say, but luckily, fortunately, in my experience, we have done a lot of defending of discrimination complaints. And every single one has been found to lack merit or no finding of discrimination. And like I said, I'm not saying it doesn't exist, but what it's done to me and the associations and managers I deal with is it's made us cynical. When you hear these things, a lot of times it's just somebody that's angry at the board because they're trying to enforce the covenants against them, as they do everyone. And they use this as sort of a sword. And then you get into, if an investigation is opened by the government, unfortunately, we've got some people in our investigatory agencies, they're activists, and they may resonate or have common ground with that complainant. And so you've already got a biased investigator. And, you know, you go back to the boards and the managers feeling like, I didn't do anything wrong. I'm not a racist person. I'm not a discriminatory person. And it's just a big conflict. And so I would like to see more objective standards, because I find that this stuff becomes very subjective. How I feel, how I took your comment, how you know, it's very internalized. And I do think, based on the new publication, that we might be headed that way. And last thing I want to say is I don't think that the people filing these complaints are really taking into account their community as a whole. They're really hurting their community, of which they are a part. These are nonprofit organizations that are funded by their homeowners. And so who's paying those attorneys' fees? You may get your $7,000 insurance payout, but what does it really cost you? And the discord in the community. So it would be great for people to come together and resolve their differences without this the law getting in the way. But I think it would help a lot if we had some better objective standards for what is and isn't. It is such a gray area of, oh, you know, the disparate impact type of thing. Go back to the intent, to the actual objective standards of, is this discriminatory or is this not? And I think we've lacked that for the last probably 10 plus years.
So there's 2 ways things are communicated here. There's the Valerie way, which is accurate, and she's a professional and she knows everything and she says things just the right way. And then there's the Ray way. Valerie, true or false? There's people that do this for a living. They're good at these claims. They know how to make them. They know how to make them happen. Chris is nodding your head. You're not going to beat them. They're waiting for the chance to sue you, and they're very, very good at it, and they do it for a living. And if you mess up, they're going to get you.
Yeah,
Valerie.
you're absolutely right, man. And I'm glad you brought that up. That escaped me. We've come into that where they're career discrimination complaint filers and they've lived in other communities. And I actually had a business idea, Ray, if you want to partner up with me, is creating a database for managers and board members to actually research the people filing their claims. Because you can already see it sometimes. They're sending the emails that say all the lingo and they want someone to respond and make a mistake. And then boom, they got the complaint and they're looking for a payout. And I actually would think it would be great if we had a database where we could search for repeat offenders where they're filing frivolous claims and getting insurance payouts. That would be great because I also think the investigators on our agencies would appreciate that, knowing that, hey, this person is making a mockery out of something serious we're trying to address.
I want to go business together, Valerie. I want to work in your office. Can I work in your office with you, like desk to desk? And then we could spend like our families together on the holidays and we can go on business trips together. I'm in. Did you just make me an offer? I'm in 100%. We'll be together like 24 hours a day. And then, Valerie, I can give you my legal opinions just on everything in life.
Ray, I really just wanted you to be a silent investor. Just give me your money.
Oh, okay. All right. I'm going to give Cameron the last word. Any questions I didn't get to, I will definitely follow up with. Let's start with Kristen first.
I think what Valerie just said with everything was great, and I echo everything. It's just please make sure that you have adequate insurance from the insurance professional here. Like I said, make sure you have it on the front end. Don't wait until you're having to send a lawsuit into your insurance professional and say, do I have coverage? Do we have this policy? Make sure you're doing reviews and make sure you're being proactive.
And actually, I'll let Cameron go second. We'll save Valerie for last. Cameron, do you think I was wrong today trying to scare people? I mean, I honestly don't like doing that, but this topic makes it. I feel bad. I don't want board members that get sued and be charged with being like discriminatory.
Yeah, it can be scary, but I think if you lean on the experts, they can guide you through it, and it's not so intimidating.
Okay. So Valerie, you have 2 minutes and you can either make me a business offer right now and accept my offer to work with you, or you could talk about this topic. Which would you prefer?
I think I would just echo the sentiments of Kristen and Cameron. Consult with your professionals and even your managers. They've dealt with this in other communities, so they're great resources. Of course, they're not going to give legal guidance and insurance. Make sure that you have insurance. I would just echo that. I don't think there's much more to add other than I think that we should do another show after some of us attorneys have absorbed the new publication from HUD.
I think we definitely should for sure. Cameron, do you just want to thank everybody for being here? And I want to thank you for having us also.
Yeah, and thank you, Kristen and Ray and Valerie for your time. This is very informative. I hope everybody took away information and learned something.
When can I come back and hang around with all your office people and just shoot the breeze and interrupt everyone's workflow and eat pastries? When can I do that again? I'd like to do it once. Anytime?
Anytime.
Can I shadow you? Valerie has already rejected me. Can I shadow you for all the time? And can I work out of your office? Nobody wants me.
Right
Okay. All right. All right. Well, we'll see. I'm not going to put Kristen on the spot. Somebody will take
Yeah, you can come here. You can come here, and then we'll take a little trip, and maybe we'll go visit that.
I'm not going. You're way too busy. I'm not. I can't even keep up with the insurance people. Forget. No offense. That's not fun. Your office. The other Ravenel's a lot of fun, and I know McCabe is. I just know it is. Your place, I don't know. But I want to thank Ravenel once again for having us so much, and thank our panel and thank everybody. And I hope to see everybody soon. Bye, everybody. Thank you.
Thank you.
Thank you.
Bye.
Bye.